Thank you for tuning in to this recording of the Summer Village of Norglenwold public engagement session for the Land Use Bylaw Review Project. The session was originally held live in person on September 2nd of this year, 2021, at the new Summer Village office in Sylvan Lake. The session was hosted by the Summer Village and Municipal Planning Services, who are the planning consulting firm assisting the Summer Village with this project. The presentation was done by Jane Dockney of Municipal Planning Services. Kyle Miller was also in attendance. During the session, and the session today, we'll provide you with an overview of what the land use bylaw is, the purpose of the project, and the process that's been undertaken thus far, as well as an overview of what is in the draft, not approved yet by Council, land use bylaw, and then some more information about the engagement opportunities that are available to you in the next steps. So the purpose of this project is to update the Summer Village's existing land use bylaw. The open house that was held and that you are listening to a recording of today provides background information and an overview of the land use bylaw to assist you as you're doing your own review of the document, and then provide some additional opportunities and information about how you can be involved in this project and provide your input to Council and administration. The land use bylaw is one of several documents that a municipality uses to regulate land use and development. There are other documents that also provide future-oriented planning direction and guidance. These include statutory plans like intermunicipal development plans and municipal development plans. Your municipality does have an approved intermunicipal development plan and also a municipal development plan. Those statutory planning documents establish policies relating to future growth and development, land uses, programming, how the municipalities will cooperate together, and then they identify priorities that have been confirmed by the community as important. A land use bylaw is a little bit different in that it's not future oriented. It's a regulatory tool or instruction manual that provides very specific regulations about how land can be used and developed within the municipality. So things like building height, maximum density for dwellings on a lot, maximum lot coverage, and other very specific regulations. It also provides information about what types of development within the municipality require development permits and what types of development within the municipality are exempt from requiring development authority approval. All municipalities in Alberta are required to have a land use bylaw. The land use bylaw establishes processes for subdivision and development applications, for notification of decisions, enforcement processes, and then the processes involved in appealing a decision related to subdivision or development and also amending the land use bylaw. The land use bylaw establishes regulations for specific and general types of development that occur within the municipality's boundaries. It also divides the Summer Village into different land use districts. Sometimes we use the word zoning to describe these districts. Land use bylaws additionally identify specific uses that are permitted or discretionary in each of the land use districts identified in the bylaw. The Summer Village's existing land use bylaw was approved in 2013, and it is currently in effect and will remain in effect until such time as it is repealed and the new land use bylaw is approved by Council. And by approved by Council, that means the bylaw is given 3 readings by Council. The existing bylaw doesn't address recent changes to provincial legislation that relate specifically to development permit processing, the subdivision processing, notification, and the appeal process. Additionally, upon review of the Summer Village's other policies, it was identified that the land use bylaw is not entirely consistent with those policies, and it needs to be updated to ensure consistency between the Summer Village's Municipal Development Plan, MDP, and the new Intermunicipal Development Plan, or IDP. So the purpose of this project is to ensure consistency with the Summer Village's land use bylaw in relation to provincial legislation, regulations, and approved statutory plans, to enable the Summer Village's approving authorities to properly address these applications. And what we mean by that is that while there is inconsistencies between the requirements under the legislation and the regulations and the land use bylaw, it does create a little bit of a conflict and creates the opportunity for an error to occur. Even though the land use bylaw is inconsistent with the current legislation and guidance from the statutory plans, the governing legislation or the requirements in the legislation applies. So it will improve the transparency in relation to the process, and it will help reduce opportunities for errors to have the documents consistent with each other and updated. One of the other objectives of the process is to provide clarity and consistency within the land use bylaw, respecting common terms that are used in a land use bylaw and the uses that are identified in the districts. And similarly, this is also intended to ensure as much as possible that the land use bylaw is accessible, and we're using transparent language and improving consistency in terms of interpretation. Finally, another objective identified at the beginning of this project by Council and Administration was to revise the document to include regulations to help protect the health of Sylvan Lake and its shoreline, and to discourage development from occurring in areas where there may be hazards, or the lots or the areas on the lots may be unsuitable for the type of use which is being proposed. So this project began in the fall of 2019. We had a meeting with Council and Administration, and then over the summer of 2020, we began drafting the document, reviewed it with Council and Administration, and prepared a revised document in the spring of 2021. In August of 2021, we provided a notification or update that would have been sent out to community members, and there was a municipal election in the middle of all of that too. So, responding to the change on council that occurred after the municipal election, we had another meeting with Council and Administration to bring new council up to speed on what had transpired between the start of the project and over the summer of 2021. And then after that meeting, an in-person open house was held. And this recording is a recording of the information presented at that open house. Over the next couple of months, Council and Administration and our office at MPS will be gathering your feedback to put together into a report that we can share with Council and Administration to help guide Council as they begin their deliberations about changes that we might need to make to the draft in order to ensure that it is providing the regulatory direction that best addresses the concerns raised by community members. We have not yet determined when the document will be presented to Council for first reading, so we're moving into that finalization process, the last stage of the project, where we seek Council's approval of the new document. So now I'd like to just go over briefly with you the way that the draft document is structured and identify some of the changes with the draft document that have been proposed that make it different from your existing land use bylaw. The existing land use bylaw is separated into 4 different parts or sections, and then the map is at the end. We find that it's a lot easier to utilize the document if we can break down some of the administrative processes, components of the document into separate sections. We have added some additional clarification or guidance and regulations in those sections so that they're bulkier sections anyway, and just for ease of use, it seems to make it a lot easier if we can separate them into clearly distinctive of sections. So a lot of the information that would have been included or is included in the general section of the current land use bylaw is now identified in those sections 1 through 7. I'll go through these different sections in a little bit more detail as we move through the discussion of the presentation. The guide to using the land use bylaw is a new addition to the document. It isn't intended to be approved as part of the bylaw. It's just intended to provide some explanation to those people who are unfamiliar with the land use bylaw about how the document is to be read and used, to make it a little bit easier to understand the context of the document. The first section of the document, the introduction section, just provides some of the bylaw component of it that identifies the purpose of the bylaw, rules for interpretation, the definitions, which is very important, and then establishes forms and fees, provides a severability clause, and the repeal clause for the old bylaw. I'd like to take a moment to talk a little bit more about the definitions. In the new land use bylaw, there are significantly more defined terms than there are in the existing land use bylaw. This has been proposed in order to improve clarity, and consistency in interpretation, and also to ensure that the terms being used in the context of this land use bylaw are consistent with the defined terms in provincial legislation and the applicable statutory plans that the Summer Village has in place. We've also added some additional illustrations to help aid with interpretation. There are terms that are used specifically in a land use bylaw that are used very differently in the context of the land use bylaw than they are in common usage. So we wanted to provide some additional clarification about how they're intended to be used in the context of this document. Part 2 of the document provides information about the responsibilities of the different bodies that will implement and enforce the regulations in the land use bylaw. All municipalities have to establish, by council resolution, a development authority. In your instance, in this municipality, you also have a development officer and a municipal planning commission who perform the functions of the development authority in different situations. Council also delegates the authority to make decisions about subdivision to their subdivision authority. And so in this section of the document, we have identified the subdivision authority, and then there's some information about how council is responsible for administering different aspects of the land use bylaw as well. The third part of the land use bylaw is the section that provides more detailed information about how a land use bylaw can be amended. So it identifies specific application requirements, what council's roles and responsibilities are in relation to considering an amendment, and then how notification and public hearing requirements will be satisfied, along with information about forms and submission requirements, and then just some more clarification about how the amendment must be proposed and what the process is that you go through. So in including the information in this section, we haven't changed the process. This is consistent with what the process would have been under the existing land use bylaw. We're just trying to provide a little bit more clear additional information about how this process works, so that if a landowner decided they wanted to propose an amendment to the land use bylaw, there would be more information about what that would require and what happens within the administrative office and within council chambers once that application has been received. Part 4 of the land use bylaw as drafted provides information about development permits and then the procedures involved in processing and issuing decisions for permits, as well as some information about what is required in a situation where there is a contravention identified in relation to the provisions in the land use bylaw. So this section is broken down into a number of subsections. One relates to control of development. And essentially this section just indicates that all development within the municipality requires a development permit unless the development is identified within the next subsection, which is aptly named development not requiring a permit. And of note, because I think there's often some confusion about this part, even if the development, say, that is being proposed is identified in the list of developments not requiring a permit, that development must be constructed on a lot in a way that's consistent with all of the regulations in the land use bylaw. So it still must comply with the land use bylaw. If it does not comply with the land use bylaw, and common situations where that might occur are things like in relation to required yard setbacks or building height, then a permit is required and a variance must be requested from the development authority. So if you're proposing to do a development that's identified within this list of developments not requiring a permit, and the development will conform to all of the applicable regulations within the land use bylaw, then those are the only types of developments that can occur within a municipality without going through the permitting process. So we generally recommend that you contact the administrative office, just have a conversation with administration about what it is that you're proposing to do, and provide them with some information so that they can help you determine whether or not a permit will be required. This section also provides information about existing non-conforming buildings and uses on a lot and how they will be handled, as well as detailed requirements for development permit applications, how development permit applications will be processed, and then some information about types of conditions that might be applied with a development permit when it is approved. This section provides information about the types of variances that may be considered, because from time to time, because of specific lot configurations or dimensions or topographical constraints on a lot, a developer may need to ask for a variance to one of the provisions, the regulations in the land use bylaw, in order to make their development work on the lot. And the legislation, as well as the land use bylaw, provides the development authority with the ability to grant a variance under certain conditions in order to enable the development to proceed. Now, a variance isn't guaranteed, and in order for the development authority to approve a variance, it has to conform to the requirements in this section, some of which are carries over directly from the Municipal Government Act. So it needs to conform to those triggers or requirements that are identified for when you may be able to grant a variance identified under the legislation. This section provides information about how notice of a decision will be conveyed and some information about when or under what circumstances a development permit could be canceled. And then it also identifies or provides a reminder about how even if you have a development permit approved by a municipality, your development must still also comply with any other applicable legislation. So the next sections are a section that provides some information very similar to the development section about subdivision of land, provides information about application requirements, processes, and the duties of the subdivision authority. Part 6 provides information about the appeal process. It outlines when development permit and subdivision can be appealed and by who. It provides some information about the process for appealing a decision and the time frames that are identified under the legislation. And then it also provides some information about the different appeal bodies. And one of the things that will be different within this land use bylaw than the existing land use bylaw is a recent change to the legislation that identified triggers for when a development permit appeal will be heard by the Provincial Appeal Board, which used to be called the Municipal Government Board, but is now called the Land and Property Rights Tribunal, or the LPRT. Until December of 2020, all development permit appeals that were initiated within a municipality were also heard by the municipality's local subdivision and development appeal board, unless you had a regional board, and then it was heard by the regional board. It wasn't until December of 2020 that the legislation was amended, and now there are some types of development permit appeals that go to the province as the appeal board. So this is a substantive change, one of the more substantive changes that need to be updated within the existing land use bylaw to ensure consistency with the legislation. Until your land use bylaw is approved, well, I guess the important point is that the land use bylaw as it's written today is not consistent with this change to the legislation. However, that change to the legislation is still in effect. Enforcement. So Part 7 deals with enforcement. So what tools are available to a municipality in the event that they're required to undertake enforcement because it has come to light that there's a development that has taken place on a lot that is inconsistent with the requirements in the legislation and also in the land use bylaw. So in this section, it identifies actions that a designated officer of the municipality may take to enforce the regulations of the land use bylaw or conditions of a development permit approval. It also identifies the rights of the development officer to inspect or enter a property to ensure compliance. And then it identifies when stop orders, violation tags, and violation tickets may be issued. Additionally, it provides some information about the rights of a proponent or developer to appeal a stop order if one is issued. In this section, we've tried to provide some clarification about the difference between the different enforcement tools that are available to a municipality, including some additional information about violation tags and tickets and stop orders. So now we get into the regulation sections within the land use bylaw that apply to how development can occur specifically on lots within the Summer Village. The first parts of the bylaw, sections 1 through 8, provide information about the administrative processes that govern the development and subdivision process within the municipality. Now we get into the regulations or the rules for different types of development on individual lots within the Summer Village. The general development regulations in Part 8 can apply to any development that occurs on any district within the Summer Village. We have carried forward those provisions that are working And then we've tried to identify areas where revisions needed to be made to ensure consistency, to improve clarity in terms of interpretation. And then in some areas, we've added entirely new sections or expanded upon them significantly in order to address what our project objectives were identified a few slides back. So the ones that I wanted to spend a little bit of time focusing on today, because we know that they do represent some significant changes for you, are the landscaping, environmental conservation and development section, the number of buildings on a parcel section, and site conditions. And I guess our hope is that you will read through the entire document with care and provide us with your feedback. But these areas in particular, we have flagged for your particular care and attention because we know that the changes in these sections are substantial and they're very important for you to review. So Part 8.11, Landscaping, Environmental Conservation and Development. This section has been added to the document, so it's new. And it indicates that landscaping shall be required for redevelopment on lots. There's some triggers for what types of development would require a landscaping approval as well. You know, if you're doing bringing a shed into your property, it's not altering the vegetation on the lot and or changing lot grading or drainage patterns, then we're not really worried about landscaping in those situations. Unless in order to bring in that shed, you are taking down trees that were formerly approved as part of an approved landscaping plan. So these sections we've tried to be very comprehensive in these sections to help identify what the triggers would be for needing an approval and where a development permit would not be required. But I guess one of our asks to you as a community member is that you have a look at this section just and give us your feedback about whether or not it reads clearly to you as well, so, because the purpose of this is, you know, it's intended to be a tool and to provide some benefit. And if it's not easy to clearly interpret and consistently interpret, then it's not doing its job properly yet. So we're seeking some feedback from you specifically in regards to the interpretation of these new sections to make sure that they read clearly and appropriately. So some of the regulations that are included in this section are a requirement for an irrevocable letter of credit for up to 125% of the cost of the landscaping when a landscaping approval is required, just to ensure that the landscaping will be carried out as per the plan. It's very difficult to often go back after the fact and deal with recovering the costs after the development has occurred. It's a lot easier if the municipality has some of that money to hold up front, so that in the event that there are deficiencies, the municipality already has the money if they need it in order to take the corrective action. Development permits may be required where landscaping would result in the clearing of vegetation, stripping, or regrading of the site. And the purpose for this is to ensure that we are developing in our lake environment in a way that has as minimal a negative impact as possible on the waters of the lake. Additionally, one of the challenges that we often face in areas where redevelopment is occurring and there was not a post-construction lot grading or drainage plan identified when the lots were originally registered, which is often the case in older communities, is that because we don't have those post-construction elevations identified for someone who's redeveloping their lot when they're doing their planning, lots, when they're being redeveloped, are often regraded substantially, and we have negative impacts on adjacent properties or municipal infrastructure or the lake as a result of those changes in lot grading and drainage, either as a result of water being shed off of the lot onto an adjacent property because the elevations are so different, or more runoff being created as a result of a significant increase in non-permeable surface on the lot draining towards the lake or even towards municipal infrastructure that wasn't designed to be able to take all of that additional water, surface water. So now, I guess, adding these provisions to the land use bylaw provides the municipality with the opportunity to take these things into consideration and to work with the developer to ensure that when those lots are being developed or redeveloped, the lot grading and drainage plan will not cause unanticipated, I guess, or unplanned for harm on adjacent properties, municipal infrastructure, or the lake. And we can only do this if we require the plan and the plan is approved as part of the development permit approval. So this section identifies or recommends that landscaping plans incorporate, wherever possible, recommendations from the Alberta Clean Runoff Action Guide, which was actually developed by the watershed group up at Pigeon Lake. And it's an excellent guide. It's available online. One of the things that we've tried to do in incorporating some of these new regulations or changes in the document is ensure that we're providing property owners with tools that they can use easily. They're accessible and they provide cost effective, so not too expensive, examples of different mitigations or design strategies that you can use to control runoff on your lot, to keep it on your lot. So there's a list of requirements for what a landscaping plan must entail in the event that the development you're proposing would require a landscaping approval. And then we've identified some standards as well for landscaping that would have to be incorporated into the landscaping plan. And you can look to the Clean Runoff Guide to provide some tools for how to ensure that this can happen on the lot. So some of the examples are requirements to conserve trees where possible, to retain wetlands, and then for screening, information about required topsoil depth, and the timing of landscaping completion. Part 8.14 of the Land Use Bylaw provides information about the density of dwellings that may be allowed on a lot. Specifically, it identifies that no more than one principal dwelling will be allowed per lot, and it also identifies that no more than 2 accessory buildings will be allowed on a lot that is smaller than 0.2 acres in area. So the second bullet there, that is a marked change from the existing land use bylaw. The existing land use bylaw does not identify a maximum number of accessory buildings. It just identifies a maximum site coverage area per lot. And this was done in order to, I guess, try to identify and ensure some consistency in terms of appearance on a lot, instead of allowing a situation where that maximum lot coverage percentage could be made up with 8 smaller accessory buildings or something in that regard. That's an extreme example. It wanted to limit the number of accessory buildings and encourage those buildings, if you needed the additional space for storage, to be larger, and just to have a more uniform appearance in terms of the development within the Summer Village. In terms of site conditions, this section has regulations that would restrict or prohibit development on unstable slopes, steep slopes, within floodplains, wetlands. Specifically in relation to wetlands, the requirement is that all subdivision and development must be consistent with the requirements in the Alberta Wetland Policy. So the Alberta Wetland Policy is a newer guideline prepared by the Government of Alberta that changes how development may occur within wetlands or on lands within the area of influence, so adjacent to wetland areas. And we're required to take this into consideration when we're looking at whether or not a proposed development is suitable in a location that's close or includes a wetland. There's also some requirements here, and these are the ones I flagged on the slide, relating to subdivision and development setbacks. These subdivision setbacks that are identified on the slide would pertain in areas where a new subdivision is being proposed, where reserves have not already been taken. So we included these in the document because they are policies that are within the approved Sylvan Lake Intermunicipal Development Plan. But I also wanted to clarify that within your municipal boundary, all of the land has been just about, all of the land that's adjacent to the lake certainly has been subdivided, and the opportunity to take reserves has already come and gone. So these 30-meter required setbacks from the bank of Sylvan Lake would not be able to be retroactively applied within your municipality. So they wouldn't apply to those shorelines within, or shorelands within your municipality. They apply to the other areas that are affected within the Sylvan Lake Intermunicipal Development Plan on lands that had not previously been subdivided, in situations where at time of subdivision reserves can be required. So just clarifying that although this is in here, it is not applicable within your current municipal boundary. If an annexation were to occur and all of a sudden there were to be more shore lands that had not been previously subdivided within the Summer Village, then these would be triggered. So it's a sort of a future-oriented regulation to ensure that in the event that your municipal boundaries changed and we did have lands where subdivision were proposed and reserves could be triggered, the municipality has regulations in the document that are consistent with what has already been agreed to in the Sylvan Lake Intermunicipal Development Plan. So don't panic on your existing lakefront lot. This couldn't be taken or triggered because the subdivision has already been registered and approved, and the time for taking of reserves has come and gone. So Part 9 provides information about specific development regulations, and what this relates to really are different types of specific uses of land that have additional regulations that the Summer Village would like to apply. So the two that I have flagged for our discussion or our presentation today relate to recreational vehicles and driveways and parking. In relation to driveways and parking, there are regulations in the land use bylaw that indicate that a driveway shall be considered to be part of the lot site coverage, along with other types of developments on the lot, and shall not exceed the maximum site coverage regulations within the applicable land use district. So when you're figuring out whether or not what you're proposing will conform to the regulations in the land use bylaw, you have to take into consideration your driveway and parking area. And I just wanted to flag that for you. That is an existing requirement in your existing land use bylaw, and we've carried it forward in this document as well. There's also a requirement for the maximum width of a driveway to not exceed 10 meters or 32.8 feet. Similarly, this is in your existing land use bylaw, and it's been carried forward into the draft document as well. And then the last provision here is that driveway construction shall not disturb or disrupt stormwater management infrastructure and shall be constructed not to interfere with the natural flow or absorption of surface water. And this is just to ensure that the Summer Village's existing stormwater management infrastructure is not hindered or impeded as a result of new development occurring within the municipality or redevelopment occurring. Recreational vehicles. So in your existing land use bylaw, the current recreational vehicle regulations are that an RV can be parked on a lot with an existing dwelling and used by non-residents for a maximum of 30 days per year, calendar year, or the owners of the lot for a maximum of 60 days per calendar year with a development permit. An RV may only be parked on a vacant lot to provide temporary accommodation for owners if a development permit has been issued for a cottage or home on the lot. So your Summer Village is not a Summer Village that allows for RV lots permanently within the Summer Village. It does allow RVs associated with existing developed lots, and it does provide a little bit of wiggle room to enable someone who's constructing a dwelling or a cottage on a lot to have an RV there during that construction period. Now, in order to provide a little bit of additional clarification about what is allowed in relation to RVs, we've recommended some changes, and those revised regulations are in the draft document. As it stands in the draft document, it states quite clearly now that the placement of an RV on a lot requires a development permit. It does carry forward the provision that says that you can only have an RV on an undeveloped lot if it's there temporarily during the construction period for a dwelling on a lot for which a development permit has been issued. It also states that it provides a little bit more clarification about how many RVs can be on a lot. So it allows for the placement of a single RV, and then it allows for a single additional RV on a temporary basis at the discretion of the development authority. It indicates that RVs will also be considered part of the lot site coverage, and that they cannot be located within the lakefront yard of a lakefront lot. So we've clarified that the maximum number of RVs that may be stored permanently on a residential lot is 1. And then we have indicated that RVs and RV stalls cannot be rented for compensation, and RVs can't be stored or used on municipal land, which is the case now. So we're just adding that for a little bit more clarification. You can't have an RV within a road right of way. That's municipal property, and it's essentially a trespass, right? So that is the case today. This is just stating it in the land use bylaw to provide some additional clarification. So our ask to you, I guess, is that you review this section in particular, section 9.8, and provide us with your input or feedback just to make sure that the way that this section is drafted right now is consistent with the way that you use and enjoy your property in relation to your recreational vehicles, your trailers, motorhomes, those sorts of things. Recreational vehicle in the context of this section does not pertain to things like boats or ATVs or those types of recreational, I guess you could call them vehicles too, but they don't fit into this definition of recreational vehicle. We're really talking about campers and trailers and the like. Guest house suites. I wanted to flag this one for you too. I think I neglected to mention that. So you currently allow a maximum of 1 guest house suite on a lot. It can be above a garage. It's considered a garage suite. If the accessory building or the guest house is within an accessory building, it is not allowed to have a kitchen or cooking facility. And they're not allowed to be rented to a separate party. So the way that the provisions are written in the draft land use bylaw, we've carried forward the maximum of 1 suite on a lot. We've indicated that they're not allowed on an undeveloped lot, so it can't go in there if you don't have a dwelling or cottage on the lot already. If they're in the principal building, they're allowed as long as there's an unfettered access to the rest of the building. And we have not provided for security suites. So a security suite would be, I guess, a residential unit on a lot with a commercial property that's intended to be there to ensure that there's on-site security. So there's no reason for that on a residential property. So we haven't provided for them in the document. So we've clarified that they're not allowed. And then we have carried forward the requirement that a guest house not be rented to a separate party, and the requirement that they not include a kitchen facility. Now, to clarify what a kitchen facility would be, we've indicated that a kitchen facility would be a food preparation area, including refrigerator, stove, and 220-volt wiring. Something that came up during the engagement session that was held, the live engagement session, is that in your municipality, you do allow cooking facilities, a second kitchen within a house or cottage within a dwelling. And I don't think that the way that the document is written right now, it provides for that. So some of the direction that we got at that meeting, and that I would anticipate will carry forward into the next iteration of the draft, is that we need to make sure that the way that the document is written going forward, it still enables that second kitchen within the dwelling. It just doesn't allow it within a guest suite that is in an accessory building. So just wanted to flag that for you because it was something that had come up. There was some discussion too about whether or not it made sense to increase the maximum height for a garage with a suite above it. We have done that. However, there were concerns raised about increasing that. So right now it's 25 feet for maximum height, or 7.6 meters. And as proposed, it's 8.8 meters or 29 feet. And so I know that's something that there is not agreement about right now, whether or not that increasing that maximum height is an appropriate thing to do. We also expanded and identified, I guess, a maximum floor area for the suites to enable a suite, say if you had a 3-car garage on a lot, to encompass the entire second floor of that 3-car garage. And then we clarified that in no instance can you exceed the maximum site coverage of a lot to put up the suite. So please carefully review this section and provide us with any input that you can to help us ensure that this section will meet your needs. So the last parts of the land use bylaw that we wanted to review with you during this presentation are the districts. So that's part 10. You currently have a shoreline residential district, a state residential district, environmental open space district, and then a community and recreation area. So these are carried forward into the new land use bylaw as well, or the new draft land use bylaw, and the areas that are within each of the different corresponding districts are identified on the land use district map. The R1 and R2 districts, the purpose, or I guess the differences between them. The R1 shoreline district, the purpose is to provide an area for low density residential development in the form of single detached dwellings and compatible uses. The minimum lot width is 15.2 meters. The minimum lot area is 697 square meters, and then the maximum site coverage is 50%. We didn't make any changes or alterations to these regulations because the lots in this area are already subdivided. So any changes to minimum, maximum areas could have a negative impact on the existing lots within the R1 district. So we tend to not touch those things in order to ensure that we don't create inadvertently a non-compliance issue. The R2 district, the estate residential district, the purpose here of this district is to provide for low density residential development in the form of single detached dwellings and compatible uses on parcels that are not abutting the lake or reserve parcel. These are the larger back lots. So the minimum lot width here is 30.5 meters and the minimum lot area is 1,860 meters squared. The maximum site coverage is also 50%, so it's actually quite large if you take into consideration the larger lot area. That's something that I'd like to leave you with as well too, to have a think about whether or not that maximum site coverage on the back lots is too large. In the environmental open space district, so these are the, for the most part, lands that are reserve lands or lands that were registered road rights of way that aren't being used, and there's no intention for these areas to be used as roads. The purpose of this area is to provide for the preservation of municipal lands in their natural state. So they're undeveloped lands, and the intention is for them to remain like that. The blue area, or CR, Community and Recreation Area, the purpose of this area is to provide an area for the development of public land for major multi-use recreational facilities and other uses listed in the district that are compatible. So it's in those areas where there may be a park or community use developed. They are municipally owned and controlled lands as well, but it just distinguishes between those areas where the intention is to leave them in their natural state and those areas where, say, lake access or improvements to the lands for parks and recreational purposes may be supported or encouraged by the municipality. So the change that was made here really was to identify the road allowances that abut Sylvan Lake as lands within this environmental open space area instead of within the R1 district. As they were identified on your existing land use bylaw map, those little areas are identified as within the R1 district, and there was some concern that there would be some pressure or someone would be interested in purchasing those lands from the municipality to develop them as a lot. And in order to discourage that from happening, they've been removed from that residential district and included in this district, so that if somebody did approach the Summer Village to ask for one of those little roads to be closed and to be turned into privately titled area that they could then buy and develop, it would also require an amendment to the land use bylaw. And any amendment to the land use bylaw triggers public engagement or consultation. So that would ensure that the municipality and all of the community members within the municipality had the opportunity to provide council with their input prior to, getting into a situation where this could occur. So it provides a little bit more protection over those areas to ensure that they remain in their natural state, which, as it's our understanding that that's the direction provided by council and administration at this time. All right, so that is a very quick overview of the draft land use bylaw. I want to encourage you again to have a look at the entire document. Those areas that, through our discussions with council and administration, we know there are substantive changes I've talked about in a little more detail during this presentation, but I don't want to discourage you from looking at any of the other sections of the land use bylaw. There are changes throughout the document, and it's important that you have a read through all of them. And then provide us with your feedback. So our office MPS will compile all of the feedback that we receive and into a what we heard report that will be shared with the community, so posted on the Summer Village's website, and then with council and administration as well, and should help to inform council's further deliberations and recommended changes to the document to make sure that at the end of the day you have a land use bylaw that works for your community and will provide the direction that you need in order to ensure that moving forward the built environment, the development within your community is consistent with your vision and the way that you use and enjoy your properties. So I just wanted to also note that there is a survey that's been posted online. It's hosted through SurveyMonkey. We have had some responses to the survey, not a lot. So I'd like to encourage you to have a look at that survey as well and provide us with your feedback through that forum if you can. The more information that we have to share with council, the better we'll be able to ensure that the document is consistent with what your community specifically needs and it's tailored to suit your needs. All of our recommendations based on the feedback that is provided will also be included in the What We Heard report, so you can see what we're doing with that information, or with what I guess the consultant's recommendation is, and then council will have that to consider as well when they're making their decisions about what changes they direct us to make moving forward. So I want to thank you very much for taking the time to listen to this presentation and encourage you to contact our office as well.